Thank you so much for joining us. You cannot avoid this story. It's making headlines throughout the country. Oscar Pistorius was granted bail of 10,000 rand yesterday at the North Gauteng High Court. While the state did not oppose bail, but it has confirmed, or it was confirmed at least, that Pistorius and his legal team will be applying for appeal on his murder conviction at the Constitutional Court, the highest court in the land there. The case has been postponed till the 18th of April 2016. We're now joined by legal expert Michael Motsoeneng Bill from Motsoeneng Bill Attorneys. A very good morning to you. Thank you so much for joining us.
Thank you so much for having me.
What do you make of yesterday's outcome?
It was predictable, and I was quite impressed with the state because they didn't oppose the bail application. I think it would have been opportunistic for them to oppose the bail application, given the history of Oscar Pistorius and the manner in which he's conducted himself since the beginning of the trial. But also given the circumstances. I mean, it's not every day where somebody gets in, gets into prison, gets out, gets in again, gets out again, and then has to face the possibility of undergoing 15 years. So I think given the history of this matter, it was quite impressive that they chose not to oppose the bail application, and under those circumstances, bail was granted.
You spoke to Leanne a little bit earlier this week, if I'm not mistaken, or last week, and you had called it that Oscar Pistorius would be charged on murder. You said you expected this outcome as well in the court proceedings. So what are you expecting come the decision on the Constitutional Court? I think I need to put my money on you. I need to bet on you.
If I'm wrong, don't invite me again.
Okay, but I really think, if you had placed a bet on it, you'd
But I mean, the Constitutional Court bid, naturally, I don't know what they're going to be bringing. I have tried to imagine what are the possibilities. I can find very little grounds to bring the matter before the Constitutional Court, at least successfully. So if I was a betting man, I would say that the grounds of success in the Constitutional Court are very narrow, given the narrow issue that was decided by the Supreme Court of Appeal. The Supreme Court of Appeal didn't concern itself with many issues other than the question whether dolus eventualis was correctly applied. Now we can't argue with the Supreme Court of Appeal because they haven't told us anything new. They've told us what we've always understood, and they've corrected the error that was committed by the court of quo. So I would struggle to imagine any possibility where the Constitutional Court can overturn the decision of the Supreme Court of Appeal and revert back to the decision of Judge Masipa.
Now, the Constitutional Court would first have to accept the case.
Yeah.
On what grounds would that be? I mean, one has to prove that their constitutional rights have been violated. What else has to be on the table for the
Constitutional Court has traditionally very narrow grounds for accepting appeals, and they used to say that they're concerned with constitutional matters. But sometimes they do look at a matter because at the end of the day, justice is more concerned. They're more concerned about serving justice as opposed to limiting themselves to constitutional matters. Now, they will look at it, but the question that one looks at in leave to appeal is, what are the prospects of success if we accept and look deeper into this matter? In other words, they examine the grounds that are raised by the defense and say, what are they arguing? And if we, prima facie, do we think that this is something that if we engage more fully, we could change the decision of the Supreme Court of Appeal? And that's their approach. And therefore, the defense team has got a mammoth task ahead of them because they got to get leave to appeal first from the Supreme Court of Appeal, just as they did in the High Court where they sought leave to appeal and obtained it from Judge Masipa. They got to obtain it from the Supreme Court of Appeal. And if the Supreme Court of Appeal says, well, we're not giving you leave to appeal to the Constitutional Court, then they can petition the Constitutional Court as well. And it'll then be the decision of the Constitutional Court to decide whether they accept the matter or not.
How long can that process take?
Another year. Assuming the matter goes, assuming the Constitutional Court accepts the matter and they deal with the matter, we are looking at some time in November again, next year, 2016.
So does that mean that he could be out until then?
It doesn't mean that at all, and that's a difficulty with criminal proceedings. In civil proceedings, when you have judgment in your favor and somebody appeals it, the effect of the judgment is suspended unless there are extraordinary or special circumstances to say the judgment must take effect despite the pending appeal. In criminal matters, however, it is rather tricky because then at the bottom line is there is a conviction that is standing. What they could look at is possibly bail in the intervening period, but he could very well be directed to serve the sentences because the appeal does not suspend what must now happen in the High Court.
Let's say the matter is not heard by the Constitutional Court and is referred back to Judge Masipa for sentencing. What will come to the fore in terms of aggravation and mitigation of sentence? Could his disability see him getting, I think the minimum is 15 years, as opposed to the maximum?
Oh yeah, everything counts, and that's why sentencing is one of the problematic issues, particularly from a point of view of a layperson, because you've heard people say, but Jub got 27 years, and they can cite you another individual who got less, and you know the lady who was convicted of murdering her husband, who was an acting judge, Maqubela. I think she got 15 years. So there's this imbalance where you're saying, well, which one is what goes, because it doesn't follow. So what determines it and what causes the confusion is that the courts concern themselves with the personal circumstances of the individual, and those circumstances could both be mitigating and aggravating. So if you then take what Oscar Pistorius has gone through, it has been a long trial. It has been an unprecedented trial insofar as media attention is concerned, and that is a factor. It has, you know, the financial difficulty that is endured, the going back and forth. Everything counts and everything gets taken into account. Naturally, the biggest one, which was also big during his sentencing for culpable homicide, is his disability. But the court has also correctly said, and that's Judge Masipa, she's correctly said that, you know, a disability is not just unique to one individual. The elderly, and she cited the elderly, she cited the young, and there are many people who live with disabilities. In fact, if you then compare Oscar Pistorius to those people, you'll find that Oscar Pistorius has overcome his disability, more than, you know, I can't run as fast as he has, and I would be called somebody without a disability. So he's somebody who disability naturally will work for him, but it doesn't weigh so heavily that on its own the court will be persuaded to give him a lesser sentence.
Do you think it would weigh in heavily, those personal circumstances, when it comes to the Concourt?
So yeah, so that's, but the Concourt is not concerned with mitigation. So they're not looking at
whether or not they will hear the case, or they'll accept it.
Absolutely
it
not.
doesn't count.
Absolutely
it's just
not.
on
We only concern
constitutionality.
ourselves with the personal circumstances when we're sentencing, because then sentencing has to take a number of factors into consideration. So you'll remember that his personal circumstances were never really entertained by the judge until such time that Judge Masipa was concerned with sentencing. And even in the Supreme Court of Appeal, there was little or no mention of his personal circumstances. And because the Supreme Court of Appeal was not concerned with sentencing, it was strictly concerned with whether the conviction rendered by the court of law was the appropriate one or not.
Now, you touched on Judge Masipa. When the matter goes back to her for sentencing, provided, of course, that the Constitutional Court avenue is one that is null and void, questions are being raised about the way in which she had seen Oscar Pistorius and was very motherly and was accused of being very lenient, etc. What can we expect from her? Because on the one side, the state is saying that, you know, she erred on a matter of law, and the defense is saying, no, she erred on her interpretation of the law. So those legal terminologies, well, what can we expect from her second time round?
I think we can be assured that personality and I think the criticism that she's motherly and all of those things, it's not something that we should be worried about, because at the end of the day, she's a professional, and the Supreme Court of Appeal has said as much. She's handled this matter in the most professional of manners. Now, the fact that somebody has erred does not then render them incapable of rendering a competent sentence. Now, and the difficulty that I personally expressed is the imposition of a conviction by another court where the fact that she's given that judgment may not necessarily change her belief. So she may still believe that the appropriate sentence is culpable homicide. So I think there will be a clash in her mind between her own belief and the imposed conviction. So that's the only difficulty. But given her professionality, she'll overcome that difficulty and she'll apply herself to the conviction, because now the Supreme Court has now given a clear direction that the sentence, the appropriate conviction is for murder based on dolus eventualis. And I just want to mention one thing. Even the Supreme Court of Appeal, you remember when they rendered this judgment, Justice Leach began by saying this is a unanimous judgment. So what he means by that, of the five, all of them agree. But sometimes, and very often, one or two don't agree, and they render the minority judgment. So that also gives you a clear picture of why Judge Masipa is still, her integrity must still be intact and is still intact, because even the 5 judges that sit in the Supreme Court of Appeal themselves disagree. And it does not therefore mean that the minority judge or the one who's a dissenting judge must then feel as if they are not competent. It's a different view, and even when we argue matter, we do refer to minority judgment.
I want to touch on that just after the short ad break. With your permission, if you can stay on for another 2-3 minutes. Sure. I want to speak about the integrity of Judge Masipa, whether or not you think she should recuse herself, and also taking a look at the legal matters financially for Oscar Pistorius and a whole range of issues. It's very unfortunate for Judge Masipa, because it looks like she's the first one to have her judgment overturned, but in fact it happens almost on a daily basis. So we'll take a look at the statistics in just a moment as well. Do stay with us.